So, Simon Howley, tax advisor.
So, I'm at a Perrotton.
You wrote an article called "The Perfect Storm" in relation to the anti-avoidance rules for claiming stamp duty land tax relief when you're transferring a portfolio of properties from a partnership into a company.
Yeah, that's in relation to Section 17A.
Yep.
Which is an old anti-avoidance rule, thought to be now pretty much redundant, but it's still there.
Why is it thought to be redundant? Why is it laziness on behalf of?
No, because there's enough anyway anti-avoidance rules to catch what certain people try to do anyway. I think the Office of Tax Simplification, which is no more because that was abolished in the government's wisdom. I think they did recommend, probably 10 years ago now, to just abolish that one.
Okay.
Yeah, I mean it's still there, but obviously we keep coming across this misinformation where you have to wait 3 years to incorporate a partnership, whether it be a general partnership or a limited liability partnership. There is no set limit. There's nothing in statute to say you must wait 3 years. So I think people have just thought about this, saying, also there is a 3-year clawback rule for SDLT, it's for group relief, it is for MDR relief for SDLT. So I think people just generally assume you must wait 3 years. That isn't the case.
So you could do it. I mean, obviously, the extreme is to then set up a partnership and incorporate the next day, but then surely you get caught by anti-avoidance provisions.
Yeah, I think that's slightly inflammatory. It's not going to work, is it really? But I think a reasonable period is anything between 1 and 2 years.
Yeah.
I think anything earlier is slightly inflammatory. But again, the partnership will exist based on its facts.
Yes.
Are the partners in partnership to make a profit? Are they sharing in losses and a risk? But you can have passive partners. You don't necessarily have to be equal partnerships. You can have someone contributing most of the capital. But yeah, it's really based on the facts of the case of the partnership. But this 3-year rule that is banded about does not exist.
So the fact that so if somebody's been in partnership with somebody else for 2 or 3 years already, on the facts of it, they've shared they've shared the responsibility, the capital, the losses, etc., but they haven't got a deed in place. How would HMRC interpret that? Favourably?
Well, the first thing they'll ask anyway, if they did inquire into it, is where's your partnership deed? So you need to have some kind of formality in that.
Yeah.
So I get a deed done, of course. That's important just to formalise the arrangement. And of course, you can't backdate a deed. That's a criminal offence, but you can refer to the existence of a partnership existing before the deed is signed. Second argument is HMRC always going to say, well, where are your tax returns for the partnership?
Yes.
So obviously you need to register as well with the HMRC and file the required returns. So that's your 2 obstacles you've got to get over.
Yeah.
Doesn't mean, however, that it doesn't exist in the first place, because you don't have there's case law where you don't. They've been investigating of partnerships without a deed in place, and it's been found to be a partnership. It's based on the individual facts. Are you trading in partnership? Are you trading to make a profit? Are you sharing in losses and profits and risks? Can you demonstrate that you work in partnership? Whatever that may be.
Yeah, because the original 1890 Partnership Act doesn't actually say that it needs to be in writing, does it?
No, but it's advisable. It's like personal agreements anyway, that they should be in writing anyway. So
yeah. So what is there in place as anti-avoidance legislation? So what is there that would stop a claim for SDLT being successful if you were trying to incorporate a partnership?
Obviously, you've got Section 75A to C. That's a general anti-avoidance rule. Doesn't need to be a tax motive for that to be triggered. Good example of that. Obviously, for the partnerships, you get special reliefs for putting assets into the partnership, and also you get reliefs for incorporation. So paragraph 18, Schedule 15. If you do the calculations and the income ratios, and you'll also connected parties. It should come out to zero, the calculation. But obviously, if you create, say, a company, a new code just before you want to incorporate, then that's going to be seen as a step by the anti-avoidance rules, and 75A specifically overrules Schedule 15. If that is the case, so in effect, it would negate the tax plan.
Is that something else that we've come over more recently? Is that obviously when prospective clients come to us, they've tended to be shopping around and speaking to various people regarding an incorporation, and several people have come up and said to us about that they have received completely opposite advice, that you should only set up the new company as you're about to incorporate.
Yeah, it's inflammatory, but obviously it's a step.
Yeah, and deliberately.
It's better to, I believe anyway, to incorporate into a company that exists or one that has some history.
Yeah.
It's easy to argue against HMRC at that point. You just have to have basically transfer the assets and you receive shares. It doesn't say it has to be a new co.
Yeah.
It just needs to be shares.
Yeah.
So yes, in my mind, it's advisable to incorporate into an already established company or established group of a company, subsidiary, or possibly the holding company, probably not subsidiary, because you might then degroup it. It's never a good thing to do. Yes, so that to me is what I would do. Obviously, if there is no company existence, then create it at the start of the partnership, so you've got something to activity within that company going forward. Yeah. Maybe buy property in that company, new ones and so on. So it exists.
Yeah, because I think with a lot of clients that they are obviously, whilst they're looking to perhaps incorporate an existing portfolio, their desire to continue purchasing hasn't diminished. So the chances are that during the period whilst the partnership has been formalised and there is effectively a wait period, chances are that additional properties will be purchased. And that can be purchased into that new company and therefore set the ball rolling with that company.
I've got a lot of clients who maybe have 15 properties in their own name with their wife or with a business partner, and also have a company as well, which owns 2 or 3 properties. So that's perfect.
Yeah. And one of the other issues that we've come up against is the whole point about lenders, and having reviewed multiple mortgage sets of terms and conditions for mortgages, it's quite clear that the lender needs to be on side with any incorporation. And
obviously, if they've got debt secured against that, I mean, there are people who develop overly complex agreements, basically with the aim just to get around notifying the lender. Yeah. If it was that simple, everybody would be incorporating. Yeah. The hard bit, if you don't, obviously you've got to fit into the criteria first for the tax rules, but if you long as you fit into that, the hardest bit is the lending side, the commercial side. Yeah. And you cannot just ignore the lender, because if you change the interest in the property, no matter how you try to do that, you have to notify the lender.
Yeah.
If you don't do that, then obviously it's mortgage fraud. If you don't do that, and it's some kind of contractual agreement with the company where in effect you try to avoid notifying the lender, and the reason behind that really is to avoid any redemption penalties, and that's also an offence for money laundering, because that's going to be a positive crime.
Yeah, I mean, looking at I've got some conditions here in events of default. You create rights or grant an interest in the property that affects our ability to enforce the mortgage satisfactorily. So if you've actually got somebody with a competing right that you haven't notified your lender about, in event, in itself, that is a breach of the mortgage conditions. And I think as well, though, that with mortgage interest rates as they are and set to sort of continue to climb as they stand at the moment, obviously there's quite a lot of clients looking at the moment to incorporate because of the advantage of being able to offset the mortgage interest once you get into a company. But they will have to sustain mortgage early repayment charges and they will have to notify their lender, and there is absolutely no way around that.
It's drafted so broadly. It's in effect, it's just a catch-all net.
Yeah.
And if people want to risk not notifying their lender, then that's rather foolish.
Well, yes. I mean, and I think the sort of the approach of how will they know is one that professionals, certainly regulated professionals, can't endorse.
Yeah, that's not really advice. How will they find out? Which we've heard that before from other providers. That's not advice.
Yes, yes.
That's like sticking cash under your bed, doing a Ken Dodd. How will they find out I'm not paying my tax?
Ooh,
Yeah,
yes.
it's just fundamentally wrong.
Yeah. So, in fairly quick order, we've then debunked the theory that you can incorporate without notifying your lender, and you don't have to wait for 3 years with a partnership in place before you decide to incorporate.
Or the planning correct. It needs to be a genuine partnership. Again, it's based on the facts. You need to have a deed in place signed, registered with HMRC, filed partnership returns, wait a reasonable amount of time, a year, 2 years, if need be, or maybe a bit longer if your mortgage lending terms kind of filter out after 3 or 4 years.
Yeah.
That's not a problem, but it's long-term planning.
Yes, no, absolutely.
It's not something to enter into straight away, enter into kind of contrived agreements to try to circumvent not notifying the lender, and cause other issues. But yeah, it's all detailed planning, and hopefully you incorporate into an established company. It's a bit safer, in my view.
And do we foresee any of this coming to an end anytime soon?
Which bit's coming to an end?
Well, the possibility of I mean, obviously incorporating has become quite popular and sort of the most recent thing to do. I guess the thing that will potentially put people off doing that is if the law changes and they decide that you can't, after all, offset your mortgage interest even in a company.
It was unusual they didn't change the rules to also affect companies, but incorporation has been around for years.
Yeah.
It's not a new thing.
No.
If you look back to when you could value goodwill, incorporate the goodwill into your company and write off your tax, they changed the goodwill rules, so you can't do that anymore. I mean, I incorporated back in 2010. So it's not a new thing.
Yeah.
It kind of ebbs and flows with the tax laws, basically.
Yeah.
So tax policy does tend to influence taxpayers' behaviour.
Yeah.
Which of course that's what tax policy tries to avoid, but doesn't really work that way sometimes.
No, well, especially when everybody's a bit squeezed at the moment, they're going to look for all sorts of ways to actually make things a little bit more profitable for themselves, I guess. So.
Well, it is, yeah. Like I say, if you have low tax rates in companies, everybody incorporates. And if you've got beneficial rates for capital gains tax at 10%, everybody wants to liquidate from income to capital. It influences them, so they bring the thresholds down because they get abused over time. It was that same as SDLT back in the Wild West days. They were massively abused, missold, or just not being used for the purpose they were designed for. But again, there's a broader issue with that anyway.
Yeah. Okay, great, smashing. Speak to you next time.
All right.
Bye.